Webinar series. My name is Chris Irons, former Commissioner for Body Corporate and Community Management, Strata Adviser, Hynes Legal. With me, as always, Frank Higginson, partner, Hynes Legal. Frank, hello.
Hello, hello, hello. Sunny Thursday afternoon.
Sunny Thursday afternoon. Hope everyone's having a good one. Yet another long weekend in prospect. Can it get any better, I ask you? Well, it can, because if you're after good content on a tough subject, then you are in the right place today. Before we get into the webinar, again, chuck some questions on live during the chat today, or indeed afterwards. We'll do our best to get to as many of those as possible. Don't forget to register for these too, because that's how you will find out what we're talking about, get some content, and particularly for next week, Frank, because next week we're releasing our May topics. You will all want to know what they are. There will be some sequels, put it that way. Well, that's what we think at the moment, anyway. But enough of that. Today, management rights, and today specifically, Frank, ending management rights, but not necessarily terminating.
No, chosen that word very specifically, and I suppose this might be a little bit more of a me one than a body corporate one. I mean, we do a lot of management rights work, we do a lot of body corporate work, so it's sort of one of those rare firms that straddles the fences. This is a topic that comes up all the time because it's well, no, we have got a program to work through, got a bit of structure in this one. So I think probably for everyone listening, it's not all about termination, because that seems to be the only option that people get put up when management rights agreements, we've got an issue. So I think there's a process we need to work through today about what are the other options other than World War III.
It's actually not an uncommon thing in body corporate land, is it, Frank, that whenever there's a problem, there's a tendency to leap to the most extreme action to deal with it straight away?
DEFCON 1, and I suppose, dare I say it, that's probably because people talk to lawyers early in the piece, and lawyers usually only know DEFCON 1, and that's what we're trying to do, I suppose, with your involvement with the practice, is saying there are more options than outright war. And this is what this is all about. And don't get me wrong, sometimes that might be the only choice you've got, but for quite often, or for many committees and bodies corporates, it's the only choice, and it's the one they first go to. So it's always going to be there, but the moment you do that, there's no stepping back from it. So there's a range of other ways. We spoke about ending rather than terminating for the purposes of the seminar, because sometimes it can be a very mutual thing. Sometimes the resident managers actually want it.
Definitely, from the ones I've spoken to, Frank. And look, when we talk about ending management rights, Frank, really we're asking the why, aren't we?
That's where it should start. Absolutely, it's where it should start. So it's a bit of a, well, you wouldn't quite call it human psychology, but it is, you know, from a body corporate perspective, there's probably a few whys. Can be personality clash, you know, just pure dislike. It can be poor performance. Absolutely, that happens. Poor performers exist in every industry, every occupation, lawyers included. So, you know, and it can be a combination of those two things. No, we're all perfect, not. You know, for me, probably there's sometimes lack of control. You know, the body corporate's tied to an agreement, and the committee might want to exert more control over how the functions under that agreement are performed. You know, gardening seems to be a prime example. We want this, the agreement only requires that, which leads to arguments about performance, personality clash, and so on. And the last one is, I suppose, in a sense, as I was running through the list of these things, might be ideological reasons. Maybe you're opposed to management rights just because they're management rights, not necessarily because of the model, not because of anything else, but I just don't believe in them and therefore they should end. So, you know, they're probably for me the main reasons from a body corporate perspective you might think about getting rid of them. And you know, part of that is tied up with probably what the body corporate is spending for the delivery of those services and so on. But even then, from a management rights perspective, sometimes management rights owners don't want it either. You know, like I've literally just come back from a quick bite to eat with a management rights client who's seriously considering saying to the body corporate, you know what, this isn't working for any of us, have them back. So they've been there for a long time. In a sense, you know, the big difference is that management rights owners have usually invested money to buy the things. This client in particular has been there for nearly 15 years. So whatever they paid for it, in a sense, has been paid off, and away they go.
It's the Gwyneth Paltrow, Chris Martin approach to management rights, isn't it, Frank?
Conscious uncoupling? Oh, my goodness. That's appalling that you asked that, and I knew it. My wife should be on this webinar. That's her sort of area of expertise. So financially, it's not common for managers to want to hand it back, resident managers, but sometimes age and weariness, end of a big dispute. The other one that we have seen a little bit of, because it's probably, we would have done half a dozen of these style of negotiations over the last couple of years. The other one, and this is really location specific, is for buildings. Noosa, what's happened up there is the unit prices have appreciated like you almost say in a Point Piper Sydney proportions. So what's happened is people who might have bought management rights 10 years ago in a unit, their unit's now worth more than what the combined purchase price was forever ago. So in that sense, they're financially capable of saying, you know what, have it back. I don't mind. So I suppose there's a bunch of different drivers for why this might happen. Predominantly, to me, it's more bodies corporates asking the question, but it definitely has come from managers as well. And I suppose we both see it, mate, from time to time, where you look at it and say, this relationship isn't working. So I suppose, and I think one of the other things that is important from a body corporate perspective and is to understand, this is the thing, it's sort of that be careful what you wish for. What happens if management rights do come to an end? What does that mean for the building?
Well, of course, some people would say a glorious utopia results.
They would. Those might be more of the ideological opponents to the management rights industry. But from a practical perspective, I think it leads to a few things. Its starting point is all of these buildings need constant maintenance. And it's pretty safe to assume, I think, probably if we're talking about ending a management rights agreement, it's probably for a building that is a bit older than, it's not something that arrived yesterday. It's been around for a while, so it's aging. So there is going to be gardens, grounds, utility infrastructure, capital projects potentially over time, and a range of other things that building is going to need done for it. So who's doing that is the first question. So, and that utopia that you mentioned before may well be the committee. This committee is particularly motivated to do all of these things, and that's great until the committee's not motivated, or they get crook, or they sell, or they have a big blue with one of the other committee members about what actually might go on. So the garden bees on Saturday stop. And then the contractors, who's managing all of those people to do all of these things? What happens when they don't show up? What happens when they do crappy jobs? They don't perform. From a body corporate manager's perspective, I know there's some body corporate management companies that only really want to act for buildings that have resident managers, because it stops some of that confusion around who's actually doing what.
Yep.
Body corporate managers don't go on site if they can avoid it. They're not there checking people in, not in a letting sense, but contractors, supervising people, arranging quotes, being there to show people around to find out where the pool pump is and whatever else it might be. They're at an office in a sense like we are, managing emails, producing minutes, making sure paperwork's in order. So quite often, this triangle of management that gets mentioned a bit is the committee, is the strata manager, is the resident manager, everyone working collectively the right way, make sure that things happen seamlessly. You take one of those legs of that stool away, and it does turn into a disaster. And the last one that I think is that people sometimes forget is that, so in management rights business, and all of the things we're really talking about today are caretaking. So caretaking services, not letting. Letting, is a function that isn't permanent in a sense. The manager's got an on-site right to operate. Their ability to operate is subject to them having appointments from letting owners, POA Form 6s. When that letting pool hasn't got someone as a central point of contact that is usually the resident manager, and they're spread all over the place in terms of management, suddenly you've got a whole bunch of agents who don't actually have a relationship with the body corporate, and 99% of them don't care about the body corporate.
It's a big point, Frank, that one that I don't think a lot of people would always pick up, that one.
No.
So
it's a collective. You know what I mean? There's that on-site management component from a caretaking and letting point of view run properly is a beautiful thing, because it actually gives the body corporate some ability to influence what goes on with the tenants or occupiers, as the legislation refers to them as, and make sure that there's some degree of interaction that is far more than what you're going to get from, with respect, a bunch of outside agents running 300 property managements under 2 property managers across a suburban area, as opposed to a building. So it's not all sunshine and lollipops. And it is, it is, what is that plan B? So if management rights are going to come to an end, that's the reality of the position for the body corporate. So it needs to sort of look at those things. But I suppose, and mate, this is one of the things that we do talk about quite a bit. So I think before a body corporate, or it's particularly a body corporate, I suppose, if they're trying to move to another system of management, why? Why does it want to do that? Why is it considering that? Is it because it believes that the management rights model is broken and this is never going to work for our building? Or is it because we've got a particular performance issue, we've got a relationship issue, we've got a really poor agreement which has no accountability, a combination of those factors? Like if we had an agreement, we're in a body corporate hat, that actually said what needed to be done, and we had a manager that was doing those things, would we be happy to continue to have this? Because to me, that's where the paths diverge. If we do believe, we, being the body corporate, in a management rights model, then let's try to work towards a process to get the right one.
Yep.
And I think that's part of what, mate, to be honest, you're about, I suppose, with us. It's this, because at that stage, it's not about legal demands and threats and terminations and all those sort of things. It's about conversations.
It is, Frank. It's about understanding context as well, isn't it? I mean, it's expectations. Committee and owners have one set of expectations. The caretaker has another set of expectations. There might be some considerable distance between them. So if there is a way to bridge that gap, isn't that preferable in the first instance? And I know I've said it in so many webinars and seminars, you don't have to be best friends, the body corporate. In fact, you probably shouldn't be best friends. You just need to be able to get along enough so that the business of the body corporate moves on day to day. That's what you're after, because it is a business after all.
But it's just this leap to termination that most people go to, right, wrong, or indifferent, almost takes away the ability to do that. Because from a management rights perspective, a body corporate saying to a manager, we're terminating your agreement, is a declaration of outright war. That's what it is. And it's really, really hard to back away from that. So I think for me, this is part of this strategic management that we're talking a little bit about today, and that's you, us, whatever it might be. You, us. You are us. It's sort of that. There you go. There's a line of. I'm talking about you as not a lawyer. So that the non-legal stuff and the legal stuff working in concert to try to come up with an outcome that actually works, that isn't only the one option, because there are more options.
As Kenny Rogers said, you never count your money while you're sitting at the table, Frank. And the same thing here. You don't play all of your cards. You don't leap to the end result straight away. So there we go. Your second pop culture reference for today, Kenny Rogers. All right. So you've gone through all of that, Frank. What then?
We've had our conversations. It's not necessarily working. I suppose in terms of how management rights agreements come to an end, probably there's some, I suppose, I want to spend some time talking about sort of negotiated outcomes, but I'll do a little bit of time now talking about almost the contractual or legal ones to start with. So this is the vacuum. So the first one is they simply run out. Like management rights agreements are like a lease. So when you go and take a lease in a Westfield or whatever it is, you sign up for a 5-year term with a 5-year option. As tenant, you pay your rent. But come the end of that, assuming you exercise your option, come the end of that option or that lease term, that lease comes to an end. And it just does that naturally by a fluxion of time. I think that's how it's certainly written, whether it's the way it's pronounced. My mother will be watching, so she'll let me know. My first job harking back for a second, in grade 7 was at Scarborough Fair, which is now Australia Fair, as a member of what I called at the time the courtesy team. Not the courtesy team. So you'd run around picking up shopping trolleys after people and all that sort of stuff. So my mum still gives me grief about that too. But anyway, live and learn. So they expire. So if the agreement's not renewed, there's no option added to it, it comes to an end. And at that stage, what the manager owns is a bunch of letting appointments and potentially a bit of real estate. That's it. So, but the difficulty with that from, in a landlord and tenant arrangement where Westfield's leased the shop to someone and the shop comes to an end, well, Frank Lowy's not in Westfield anymore, but Frank wasn't walking past the shop owner every other day saying, I'm going to run you down, mate. When your lease expires, you've got nothing. In a body corporate context, that is actually what happens, because we've got this relationship of physical proximity. So while that sounds good in theory, and in theory it's possible, in practice it's really difficult, because most managers don't have agreements that last for 6 more months. They might have 6 years, they might have 12 years, they might have 18 years. So at that stage, running it down is going to outlast everyone's lifetime in that particular building. So that, to me, again, good in theory. If a manager has let their agreement get to the stage where there's only 6 months to run, then that's the danger that they're in. From a management rights perspective, it's certainly good practice to top your agreements up regularly to make sure that doesn't happen to you. And if it does, if you do get your top-ups, then you've got the time to run. Because these agreements, these management rights agreements, don't come to an end absent something being specifically written in them, unless it runs out of time or there's cause. Because the other thing, and a bit like a lease and an option, option and a lease, agreements, you might have an agreement of a total of 25 years, but that might be broken up into a 5-year term and a bunch of 5-year options. Those options usually are exercisable at the discretion of the manager, and the manager needs to physically do something for an option to come into existence. And it's not uncommon. We get this probably once every couple of months where someone's forgotten to exercise their option, and the agreement at that stage comes to an end. So that's, if there's a resident manager watching this, you need to know your option dates. We can help remind you of those if you need them. We do that for our management rights clients, because it's very easy to forget those things, because they can be 2026. And if you're still there, trying to remember something from 5 years ago can be a little bit difficult. When really date specific. So options, termination for cause. So this is, the agreement provides certain termination rights. The module provides certain termination rights. One of them might be that the manager is licensed as required by law. That might be an obligation in the agreement. Certainly is under the modules. No license required from a caretaking perspective. There is a license required from a letting perspective. So if, for example, the manager is convicted of trust account fraud and loses their license and can't get a license, then they're not licensed as required by law. Bang. They might be convicted of indictable offence involving fraud or dishonesty. That could relate to trust account fraud. That may well lead instantaneously to a right of the body corporate to terminate the agreement if it goes through the proper statutory processes. So that does happen. We have seen that. And for those ones that are very factual and uncontested, there's nowhere for the manager to hide. So the agreement can come to an end that way. But of course, that requires some fairly significant malfeasance on the part of the manager. That's not an immaterial thing. That's a major thing. The next one, and I suppose we'll spend a second here because we made a specific point earlier about not using the word termination. Termination for cause that's disputed is a very difficult battle for everyone, is the reality of it. And the only winners of these types of battles are the lawyers. In theory, the clients might win, and Chris, I think you've got a couple of things to put up there. And probably the one example I've used is a recent termination fight, relatively 3 years ago, as much as you'd think COVID would slow things down, but it hasn't. So this is one at the Grange. And what we'll do is put up the judgment, and we'll put up the article I wrote about it at the time. So have a read through that if you want to see what happens in a battle of termination for cause, which is contested. So when I mentioned cause before, it's sort of uncontested, bang, trust account fraud all over. No arguments, factually correct, done. If you're going to have a go at termination for cause about defects of duties and all that sort of stuff, this is the sort of stuff that you might go through. So collectively, the parties there spent 900 grand on legal fees. Body corporate lost. It was ordered to pay costs, so it wore 300 of the manager's costs in that. So the body corporates ended up paying $750,000 for a dispute. It didn't win, and the manager still ended up paid 130 grand out of their own pocket for a dispute it did win. So again, winners are the lawyers, and that's the sort of process, that's the worst case scenario that you might finish up in. You run this whole thing, it takes years, and you lose.
Yep. That's a lot of money, Frank.
That is a lot of money.
That money stays there too. And the body corporate's going to have to pay for that somewhere, somehow.
Absolutely. And it's really interesting. I put a comment on that in the decision at the time, where when the arguments about costs were going up, at that stage, of course, the body corporate had suddenly woken up, or the committee had realised, hang on a minute, or the owners, what the hell is going on here? Because they'd let the committee run it. And one of the defences that the body corporate ran to say why costs shouldn't be awarded is the owners weren't aware of what was going on. And the member said, yes, they were. They had the opportunity to exercise influence at general meeting, and they didn't. So if you're asleep at the wheel, you're asleep at the wheel. Don't go blaming someone else. So probably those are the contractual and legal ways.
What are some of the other commercial ways, Frank?
Yes, and this is really the joy of these things. So probably something that gets bandied about a little bit. So a body corporate can't run a business. Can't run a business. So leasing a piece of common property, say for a telephone tower, is not running a business. That's an exercise in a property right. Running a business is doing what we're doing, I suppose, in a sense of providing services, all that sort of thing. So a body corporate cannot actually operate a management rights business. So you see this, haven't seen one for years. There's a couple of legacy ones lurking around where what happened over time is body corporate had management rights, or had a management rights in existence, and what happened over time was the owners or group of owners got together, tipped in a bunch of money, created an unlisted public company with all of them as shareholders, and that company then purchased the rights from the entity that owned them. So what you've then got is effectively the same structure. You've got a body corporate, you've got a management rights company. It's just there's some, I suppose, consistency of ownership, or more consistency of ownership between the two groups. Now that is horribly messy in the long run, because an unlisted public company is a whole lot of corporate compliance. You know, your accountants, not body corporate managers, to run them. And of course, you're still with the management rights model, because normally what I've seen is the people who put together the money to buy the thing are normally on the committee. And then when you actually have an interest in the management rights business, you can't be on the committee. So suddenly they need a new committee. So suddenly you've got the committee, in a sense, morphs across to be the owner of the management rights, and then you've got a new committee coming in, and you might end up with the exact same situation that forced the committee or made the committee desire to do it. Leaving aside, over time, people might sell their units, and do they sell their shares? So you're talking stapled securities and all sorts of legally messy things to try to tie it together. So practically, that doesn't actually work, I think, in the long run. Again, might sound good in theory, like the utopia of we'll run our own business and we'll run our own management rights and do all the garden bees, working bees on Saturdays. But the last one really, and this is where we've got to, and this is what we've done a bit of over the last probably 2 years, to be fair, it's where a body corporate and a resident manager reach a commercial agreement to bring the agreements to an end. So I suppose this is sometimes referred to as a body corporate buying the business. Like I said before, it can't operate a business. So what happens legally is that a body corporate will pay a fee or pay a consideration to a manager to agree to surrender their management rights agreements. So it's not quite buying it where you take an assignment, which is what normally happens. It's here's X dollars for you to surrender your interest in the caretaking agreement. Because in a sense, the body corporate's got nothing to do with the letting. So the body corporate can continue to let the manager let. It can continue to do the letting appointments, or the manager might choose to pack the whole thing up, sell its appointments to an adjoining building, outside agent, whatever it might be, and walk away. So it's important to understand that that's the starting point. It's a payment of a fee in exchange for a surrender. And then I suppose you've got to look at, for everything. So it really becomes a business investment in a sense. We're going to spend money, we're going to get a return. What does that look like, and are we happy to wear that? So from a tangible perspective, you'd almost look at from a body corporate perspective. We're in the body corporate hat. What's the body corporate spending on caretaking? How much longer has that spend got to continue? What will the spending needs be without management rights there? We spoke about that before, Utopia. Is the committee going to volunteer to do all of this for free forever? For me, probably not, but stranger things have happened. So what are the spending needs going to be? So that's probably part of the financial consideration that needs to go into it. From a body corporate perspective, how that fee or that consideration is going to be funded is the other thing, because bodies corporates can raise special levies or they can borrow monies to actually do it. Different thresholds for both of those, but probably the thing that is almost certain is that the sinking fund isn't going to have an amount set aside in it for the payment of a fee to the manager to surrender the management rights agreements. So that's going to be raised from owners. And certainly one of the ones we've done included some vendor finance. We're acting for the manager. We agreed a consideration, and that was paid a lump sum up front and then 2 payments over a period of time with some remuneration attached to it. With some interest attached to it. So you can be a little bit flexible about how that actually might look. And then I suppose the other intangibles that go into it, subject to what your particular situation might be, from a committee perspective, what price do you put on control? We've got rid of this. What price do you put on particularly issues where the relationship might have completely descended into the abyss and it gives the chance for everyone to walk away and get out of it? And even one of the ones we did included, perhaps a little bit unlawfully, but our client as manager was happy to do it, that you sell the lot and go as well. We'll agree to take the rights off you, but you've got to get out of the scheme. We don't want to have anything to do with each other. It had been going on for that long, which our manager client was happy to wear too, because they were also happy to walk away from it. So there's a few moving parts in that. So it really is a commercial negotiation is where it gets to.
Frank, do you think we'll see more of those coming up?
Yes, I do. I absolutely do. And it's probably a bit of real estate valuation increasing, probably the availability of the cost of funds, the degree of control that some people want to have. And to be honest, you go back to that Grange decision, spending 900 grand and 4 years of your life having a massive blue about a whole bunch of issues, life is too short for that. And I think probably the only people that actually do suggest litigation as an outcome are people that have never been through litigation. You've only got to go through it once or twice to realise it's actually not fun. Sounds good in theory. Again, Ally McBeal might indicate otherwise, but it is a horrific place to be.
I've got a question, Frank. Is it possible to rewrite flawed clauses in a management agreement during the term of the agreement, and is it advised?
Yes, and I think we're not going to have time to get through probably the part 2, Chris, here for that one for Sandra, is absolutely, we're back to that why component. If we're having issues, why? Is it because the agreement's poorly worded? Is it because we've got an issue with this manager and we'll happily give a new agreement to a different manager with a different set of duties? I mean, we're acting for a body corporate right now where that's the case. So what we've got is a relationship breakdown. Body corporate has said to the manager, if you go and you agree to these things, we'll add 5 years to your agreement to give you the ability to go. And the manager said, thanks very much, I'm out of here. Here's the buyer. So what I would say to that is you can't, so a management rights agreement is a contract. You can't change a contract unless both parties agree to that. So it's not going to be a one-sided, here's the changes, but it's a commercial negotiation. There might be a bit of strategy that gets you to the stage where that's going to be on the table to be discussed.
Definitely. Sorry, Frank, there's another question there from Grey Palladium. You've just clarified what I was going to ask. Why do you expect to see more walkaway type buyouts in the future? I think you touched upon this, didn't you, Frank?
To a degree, I think because people are going to have to start to realise it's an option. That's the thing. Like this to my knowledge, and that's why we put this on the list of ending management rights agreements, this is the first time I would have thought anyone's ever spoken about these being options publicly. So people don't know that they are options. So part of why we're doing these things is say there's more to dealing with one of these issues than outright termination. So here's another way, and this is the commercial approach to it, that bodies corporates can look to adopt. So you've got to start the conversation somewhere. Because to be honest, a big 4-year long drawn out legal dispute, for a manager, they've got the commercial incentive to grind it out as much as it will be draining on them. The committee is doing it for free, and it will absolutely be draining it on them. So for people to realise that there is another thing or another option to explore in itself should lead to more conversations about it, which is what this is about. And great if it turns into legal work for us, happy days. But things like the grains that we put up there before, that's not in anyone's interest.
I wouldn't have thought so.
No, and the thing is, one of these deals, assuming that one's actually reached, is an ordinary resolution. It's not special resolution. It's not resolution without dissent. It's an ordinary resolution to walk away. So we even had one that didn't quite get there, where we're acting for a manager who was couldn't get through their committee about having this conversation. So he said, you know what, let's put a deed of surrender for a consideration up at general meeting and see if owners will vote for it, regardless of what the committee wants. We'll walk away. Here's the price. Here's the terms. So that'll be that didn't happen for a number of reasons, but would have been a really interesting one to run. So, both it's a commercial negotiation rather than cudgels at 10 paces belting each other through the lawyers. And
cudgels,
again,
that's fantastic.
Don't get me wrong, that might be the only choice you've got on either side at some stage, but it's not the only choice at the outset. That's what we're trying to get to here. So, and I think probably the Sandra one is another webinar. So really, I mean, there's our half hour gone again. Most of it's been me. Sorry, Chris.
That's all right.
There is to reach the stage where people are willing to have an adult and commercial conversation about value and walk away and probably try to let some of the emotions go out of it is the difficult thing. So I suppose we see it all day, every day, where people come to us exhausted after 2 or 3 years of this. And at that stage, then they're conditioned, not by us, but they're conditioned to, okay, what else can we do rather than this? And so part of these webinars for me are letting people know that you don't have to go through 3 years of termination pain if there is a will to actually do something commercially sensible. Because after 3 years, everyone's burned out. Might be the adult conversation, and at some stage, it's the same sort of thing we have with staff to a degree. And we had, sometimes people aren't built to work together.
Conscious uncoupling again.
It is. It's really sorry. This isn't the place for you. So, and then we're back to, is it management rights or is it you as a manager? And then let's look at the alternatives to actually moving on. And so, Chris, maybe there you go. That is another webinar, which we will do, Sandra, because it's a perfect topic in terms of, okay, we believe in management rights as a model. We think we need it for our building, but we have issues with it. How do we solve those?
Yep.
Because that is also another way to cut off all of these termination wars.
Yet another part 2 coming up. We have well and truly hit. No, gosh.
On my soapbox.
There was a lot there to cover, Frank, and there still is a lot there to cover. And I think the message is loud and clear. Leaping to the end result is rarely the answer. And there are many more options than you probably think. Hopefully, you've gotten a few of them today. Stay tuned for the follow-up, sequel, reboot, whatever of today. That will be coming up. Stay tuned for the May webinar topics, which we will release early next week. And don't forget to register. That's how you'll get the information. You'll also get the much talked about and hugely popular To Be Frank column as part of that as well. That's essential reading for anybody in the sector, that one.
You idiot.
It's true. For now, though, thank you so much, everyone, for tuning in. Frank, thank you.
Thank you, everyone.
We'll see you next week.
Bye.